Good evening, friends. It's around 2 weeks back when I started this channel, Ideas and Perceptions. As I stated, I have taken up a subject matter, law. I try to understand the idea behind it and its perception from ancient times. Let us say, in a nutshell, what was the idea of law and how it was perceived by the lawmakers at that point of time. Ancient civilizations laid the foundation for many legal systems that influence modern societies. Law in these societies they were linked with governance, behavior, resolve disputes, and maintain order. Interestingly, these all concepts are also part of law in the present times also, as these are the issues of governance, law and order, etc. Now let us see the concept of law in ancient legal systems and that is available in ancient civilizations. In a Sumerian civilization, the most important concept was Code of Ur Nammu. It was 2100 BCE. Now, interestingly, these laws were about property rights, marriage, and personal injury. Very famous king, Hammurabi, in Babylonian times, made a code which is known as Hammurabi Code. It was a comprehensive legal code. It introduced the concept of an eye for an eye, and they covered a wide range of laws for trade and contracts, etc. Now, even in the Egyptian civilization, one of the oldest civilizations, you will find the concept of math, M-A apostrophe A-T, the principle of truth, balance, and cosmic order. Pharaohs were considered to be the follower or based the divine order, and that divine order was central to the justice system. Now, these laws interestingly also covered property rights, contracts, theft, and violence, etc. Now, if we see in ancient India also, certain concepts during the Indus Valley civilization or the Vedic period, law were influenced by religious principles and were based on varied systems. For example, dharma, the concept of dharma, it was a central idea in early Indian law. Manu Smritis, known as the laws of Manu, now laid down the laws of regarding social behavior and emphasized on duties, rights, and laws based interestingly on social hierarchy, that is the Varna. Interestingly, during Chinese civilizations also, important ideas that influenced law and system to govern was Confucianism and legalism. They were the two major philosophies and they influenced the ancient Chinese law. Now, Confucius emphasized on moral order, while legalism stressed strict laws and harsh punishment to maintain authority. Now, the Greek civilization, known as the basis of democratic traditions, in the different city states they have the different kind of systems. In Athens, The Dracos created a harsh legal code in the 7th century BCE, followed by Solon's reforms, which softened the punishment and introduced democratic legal principles. Now, let us see the Roman civilization. The Roman civilization, the ancient law of Rome period, it is a significant influencer on modern legal systems, and it has been followed primarily in Europe and the America. Now, what was the basis of this law in Rome? The 12 tables, c. 450 BCE. Now, it was first written legal codes. Over times, Roman law evolved into the corpus concept known as corpus juris civilis, known as Justinian Code in the 6th century CE, and became a foundation test for modern civil law. Let us see also the Hebrew law. The Torahs, particularly the first five Bibles or books of the Hebrew Bible, it contained religious and commandments known as the Mosaic Law or Law of Moses. Now, if we see, there is a very famous Maya civilization also. Maya civilization also, they had also principles on related to theft, murder, property rights, and matriarchal disputes. Now, so in way it can be said that Asian legal systems were deeply connected to religion, social hierarchies, and governance structures. And many of these concepts, such as property rights, contracts, and the distinction between civil and criminal laws, they have influenced modern legal frameworks. Now, let us see this entire introduction about the concept of law of ancient civilizations that I've tried to elaborate has only one basic objective: to state that the ideas over the period keeps on changing its forms and structure based on the requirements, necessities, compulsions, and the social hierarchical structure of those days. Now I'll be talking about the concept of law in the Indian context. Particularly for a few lines I have also earlier mentioned under the Indus Valley civilization. But now I'll be talking a little bit in detail. Now undoubtedly, it has a rich and complex legal system, and it spans thousands of years, influenced by its diverse cultures, religious and civilization. Overview of land or law in India from ancient times to the modern era has been remarkable. There is a continuity in the process of certain concepts which we'll find as I elaborate my submission. The basic component of the ancient Indian law, one of the basic components was dharma. Law was deeply intertwined with dharma, which referred to righteousness, moral duty, and the path of justice. Dharma governed not only religious behavior but also societal norms, political governance, and individual conduct as well. Another component of Indian law, which influenced later on so many other legal texts, was Manu Smritis, known as laws of Manu. now written between 200 BCE and 200 CE. It is one of the earliest and most influential legal texts in India. It states the laws regarding social conduct, family relations, property, inheritance, and punishments, etc. And the Manusmriti laws are highly stratified and, most importantly, emphasize the role of caste, varna, in law. Then, Smriti texts such as Yag Navalkya Smritis and Nara Smritis also played an important role in the development of Hindu law. And they dealt with topics such as contracts, debts, marriage, and inheritance also. After this very important text in the Indian context is Kautilya Arthashastra. It was composed around 300 BCE. This treatise by the scholar Kautilya, also known as Chanakya, is a detailed work on statecraft, economics, and law. And primarily, it focuses on governance, law, and enforcement, and the administration of justice, emphasizing the king's role as a protector of law. Now, let us come into the medieval period now. In the medieval period, Islamic law, Sharia, with the arrival of Islam in India in the 7th century and the establishment of Muslim rule under the Delhi Sultanate 1206 1857. Islam law or Sharia became the prominent Muslim law, and Sharia courts dealt with personal law matters such as marriage and religious functions, duties for Muslims. Another concept in the Muslim law was Fatma al Magheri. It consists of an established by the Mughal emperors Aurangzeb in the late 17th century. And it was a compilation of Islamic laws to be used by judges, qazis. And later on, Jahangir also followed this legal practice across the Mughal Empire. Now, let us come into the colonial period now. In the British colonial period, when it started from East India Company onwards, the British colonial rule had a preferred and a profound impact on the legal system of India. The East India Company and later the British Crown introduced the English common law system in India. And they also codified laws like they codified Islamic laws, laying the groundwork for modern Indian legal system. They, the many codified Indian laws were Indian Penal Code, IPC 1860, Indian Evidence Act 1872, Civil Procedure Code CPC 1908, and Criminal Procedure CRPC 1898 codified. And interestingly, uh, over the period of time, the government of India and the people uh, who are in the realm of law and governance examined these laws, and they have changed these laws as Bharatiya Nyaya Sanhita 2023, Bharatiya Sakshya Bill 2023, and Bharatiya Nagrik Suraksha Sanhita 2023. Now, these changes have taken place as the stakeholders and the government agencies, judiciary, legal luminaries, they have seen, examined, and critically examined the impact of these laws over the period of last 200 years. And they found that in changed democratic scenario in India, these codified laws are redundant and as per the requirements and the necessities of the present day society, it has been changed as Bharatiya Nyaya Sanhita, Bharatiya Sakshya Bill, and Bharatiya Nagrik Suraksha Sanhita. Now, this is here is a correct, a very apt example where an idea of law, as has been perceived during a particular period of time, was realized to be changed, and that idea came as as per the experience that the system got during the last 200 years, and therefore it has been done for the sake of good governance and giving an appropriate justice to the masses. Now, the British introduced also the dual legal system. They applied English common law in the higher courts while allowing the traditional Hindu and Muslim personal laws to govern family matters such like marriage, divorce, and inheritance. Now, sorry. Now let us see the idea of what was the idea of law post independence. The post independence, the idea of law, the basic document is the Constitution of India 1950. Without going into the detail, it must be said that the Constituent Assembly members, they were having a high intellectual background, different ideologies, and have experience of different legal systems as they were mostly prominent barristers, advocates, socialist economists, and so on and so forth. And their combined intellectual knowledge and background, their perception about the law in different countries like Britain, America, Irish, Ireland, France, even Germany also, they have studied these constitutions deeply and they have taken the best out of them and incorporated in our constitution. So it may be said in all fairness that Constitution of India is a basic idea of law which has been perceived during last 70, 75 years, 70 years or more so by the government, by the judiciary, by the social activists, and they are also scrutinize those things, sometimes necessitating or encouraging or prompting the amendment of the constitution also to cope up with the realities of society needs. There is a long list of amendments which itself indicates how the idea has to be perceived differently and therefore the necessity for amendment in the constitution. Now, most important things, as I've said, there are the features of British, American, Irish, French constitutions are there, features are there. So, our constitution is a happy amalgam of the best of the different constitutions of the world. For example, we have a unitary system, we have a federal system, we have a fundamental rights, we have a directive principle state policy, we have personal laws for different things. So, the basic feature, the basic idea of law, which there are two parts, part 3 and part 4. Both the parts, one is justiciable, fundamental rights, and directive principle state policy is not justiciable, but has been influencing the framing of laws and policies for the government in the interest of the people of India. So, directive principle, state policy, fundamental rights. Then we have a judiciary, which is a unified judicial system with the Supreme Court at the top, followed by High Court at the states and the subordinate courts. The judiciary is independent. Prominent feature is judicial review, which is very much akin to the American judicial review system. We have a personal laws. The personal laws ideas are basically they cater to the religious beliefs and faiths of the different communities. We have a personal laws for Hindus, Muslims, Parsis, etc. And there is also a directive principle state policy to have a uniform civil code. Now, these two ideas are a permanent feature of the Constitution, and therefore, there is always a tendency and an effort to go for a uniform civil code as it is a part of the directive principle of state policy. Of course, the minorities' sensitivities and the local political imbalances or sensitivities are involved in the process for uniform civil code. Now, if you see uh, the modern Indian legal development, you see there are uh, during last so many decades, there have been many progressive uh, decisions or acts passed by the judiciary and legislation, which was perceived as a necessity in the realm or in the context of harsh realities of society at large. The most important and significant development was the introduction of PIL, Public Interest Litigation, known as PIL in 1980s. And our Indian judiciary introduced PIL to make justice more accountable. It allows any citizen or organization to file a petition in court on behalf of marginalized or oppressed groups. This is a very important development that has taken place in the post-independent India. There has been many progressive judicial decisions that has taken place as the idea behind it changed due to the perception of the society's needs, aspirations, and expectations from the society or from the government. One of the very important progressive judicial decision that played a role in the advancing human rights. For instance, decriminalization of homosexuality in 2018, the Supreme Court struck down Section 377 of the IPC, which criminalizes homosexual relationships. Another important judgment, right to privacy. Supreme Court ruled that the right to privacy is a fundamental right under the Indian Constitution, and this judgment came in the year 2017. Similarly, due to the development, the progressive developments of the society, due to the education, due to technological, scientific developments that are taking place in the society, every section of the society is getting empowered and knowledgeable, and especially for the women. Progressive laws such as women rights and legal reforms. Now, these have been many legal reforms to protect women's rights against Dowry Prohibition Act, Sexual Harassment Vishaka Guidelines, and Domestic Violence Protection of Women from Domestic Violence Act 2005. Similarly, there are challenges also in the Indian law. Challenges are the judicial law, judicial backlog, millions of cases are pending, corruption within the legal system, and then access to justice. While India has a well structured legal system, many citizens, especially in rural areas, face difficulties accessing legal representation and legal aid. Now, the another important legal judgments that has changed the concept or idea of Muslim marriage is known as triple talaq in 2019. The Indian Parliament passed a law criminalizing the practice of instant divorce, talaq-e biddat, in Muslim personal law, furthering gender justice. Now, apart that, in India, there are many progressive laws which are related to environment. Now, if we see the idea of environment, Vatavaran, as you'll find in our ancient civilizations, that how the people used to worship tree, rivers, and they live in the good atmosphere. Now, it is because of the industrialization or urban planning that this balance of ecological balance has been disturbed. And therefore, there have been many landmark judgments by the judiciary to protect the environment. And India has developed a strong legal framework for environmental protection with landmark judicial decisions. And these decisions, they are related to the themes such as pollution, deforestation, and climate change. I can quote many cases on the issue of on environment, but it will be another big story, which is not part of this my present presentation. So in a way, it will be said that Indian legal system is a unique blend of ancient culture, colonial influences, and modern reforms. It continues to evolve, balancing the needs of its diverse population with while upholding democratic principles and human rights. Though challenges like judicial delays, delay of justice, and corruption persist, Indian judiciary and legal framework remains crucial to maintaining the rule of law in the world's largest democracy. Now, here I would like to end my brief talk by simply stating the fact that the concept of law that I have taken, I never realized that its scope is so wide that to speak on every aspect of idea of law over the period, it became a Herculean task, rather impossible also. But I did try in my most humble way, and I expect my learned uh, audience and those who are listening to my talk will appreciate this fact that if I have missed little links here and there, it is because of the positive type. Nevertheless, if we see the evolution of the concept of law right from the oldest civilizations to the present day nation state system, we find that the issues are primarily related to governance, law and order, social interactive activities like contracts, and civil and criminal activities and punishments thereof. Now, whether they are a purely legal outcome of the idea of law or it was influenced by religion, by theology, by philosophical principles, or by religious leaders from time to time, it has a altogether different story. But they all have played, for example, in Chinese system, Confucius played an important role. In Egyptian pharaohs, and even the medieval law also, there are a lot of commonalities there. So religion, culture, traditions, they always played a very crucial role in different societies at different point of times. However, as we see the world, either it is a democratic world or a, or you can say uh, not that democratic in the sense as we find America or Britain or India, but do have a constitution in almost every country. Therefore, some law is there, and on that law, on the basis of that law, that society, that government is governing. And now it evolves from time to time because of the those who are running the show and those who are following it. I hope that as and when this evolution process takes place in any society, the people and the stakeholders and those who are responsible in leading the society, whether they are a political leader or philosopher or social activities or NGOs, they will take the people of their area, of their country, in the right direction and have a fair, reasonable, just law for the governance and their happiness in the society. Thank you very, very much.